In the spirit of reconciliation, Herbert Smith Freehills acknowledges the traditional custodians of country throughout Australia and their connections to land, sea, and community. We pay our respects to their elders past and present, and extend that respect to all Aboriginal and Torres Strait Islander people today.
Welcome to On Just Terms. In this series, we look at the changing nature of corporate risk in Australia by speaking to the people at the front line of Australian litigation who will shape the future of the Australian legal risk landscape. In this episode, I'm delighted to be joined by Elizabeth Collins SC and Imtiaz Ahmed of the New South Wales Bar. Liz was called to the bar in 1996 and took silk in 2010, practicing in the areas of commercial law and taxation. Imtiaz was called to the bar in 2010 and practices in corporations, equity, competition and insolvency matters. Both are deeply experienced in the conduct of class action litigation, including shareholder class actions. In today's episode, we'll discuss advocacy in complex commercial litigation, the operation of the class actions regime, and the nature of practice at the commercial bar. Liz and Imtiaz, thank you so much for being gracious with your time to join this episode of On Just Terms. We've been exploring with our guests the litigation and regulatory environment in Australia and what that might look like in the next few years. And obviously we're in a period where royal commissions are more popular, the rise of class actions continues unabated. We're seeing contingency fees in some jurisdictions, greater emphasis on regulatory actions, AUSTRAC, APRA, ASIC. I wanted to talk to you both as practitioners in this space, what you're seeing in terms of the changing nature of litigation and where the risks might arise for corporate Australia in the next few years. Maybe starting with you, Liz.
There seems to be an increasing amount of litigation from my perspective. I think the regulators are probably better funded than they were a few years ago under the previous government. There's a few more teeth. They've been the subject of more criticism, and that, as you know, feeds into class action litigation. I mean, the Royal Commission has been the source of, I can think of 5 or 6 class actions. And I think that means that hopefully that will translate into corporates being very conscious of their legal obligations and hopefully ultimately an upskill in standards.
And Imtiaz, what are you seeing in the environment?
Look, I agree. I think I'm seeing an increase in the number of class actions, but also class actions moving into slightly different areas than one might have seen previously. So for example, I think there's at least an inclination for people to bring class actions in relation to competition law cases. So we're seeing a few of those now, which previously we hadn't seen. And I suspect that's something that's likely to increase.
Did you both think that, to Liz's point earlier, that with funding is always an issue for our major corporate regulators, but there seems to be a greater appetite to pursue larger cases, perhaps post-Royal Commission, as you say, Liz, that's the flavour. Do you think that they will target those big continuous disclosure cases, those big directors and officers' duties cases, or will they continue to look for the lower hanging fruit where they can get some sort of regulatory outcome? What's your sense of how the regulator's going to approach the next few years?
The regulators generally seem to look not so much to low-hanging fruit. Yeah. There's a series of cases in my experience, ASIC uses as test cases for companies that have gone into liquidation or administration. The FOFA reforms, there's a series of cases which involve companies who've failed to test the legislation. But in terms of big dollar litigation, they go after big corporates in my experience, and I think the funders are the same, and that's largely driven by economics because the cost of those sorts of cases is very large. There's a lot more English funders in our market and they're interested.
What about, are you starting to see a greater focus in our market on cases that focus on directors and officers' obligations? Because obviously in the class action space, they're less likely to be targets. But I'm thinking from a regulatory perspective, it seems that ASIC I think Joe Longo announced that there's a top 5 priorities now, and directors and officers' obligations are going to have a refreshed look. In your own practices, are you seeing more instructions in that space, doing more work representing individual directors and officers, Imtiaz?
Yeah, look, certainly there's, particularly with large corporates, there's a focus on protecting directors and officers where there, for example, is an investigation. So I think that's certainly something that corporates are looking at. From a regulator perspective, I haven't seen so much a focus on attacking directors and officers. From my perspective, it's more a case of looking at cases on a case-by-case basis and saying, is there a case in relation to this corporate? What flows from that case? Does it involve directors or officers? So in a sense, it starts from a slightly different perspective.
Let me ask you about how you like to work in this space. You've both got very large practices. They're very diverse, but a lot of it focuses on what I'll call high-end corporate governance, continuous disclosure issues, compliance with those kinds of obligations at the corporate governance level. They're big cases, they're complex, they can take years to resolve, they may culminate in a trial. Can you share your own experiences with how you like to be briefed, how you like to work with the solicitor teams? What are the good experiences, what are the bad? I think our audience would appreciate having a line of sight as to how barristers actually work in the cut and thrust of modern litigation.
When you're taking, from my perspective anyway as a barrister, when you're taking on a big matter, you want to know it's going to be managed well. And there are some people who manage firms who manage things better than others, and that's very important, and you want to know it's properly resourced and to do that. And the perennial nightmare from a barrister's perspective is that everything blows up in all your big matters at once. It's like both children being sick in the middle of the night. You can only be in one place at one time. But it's just, if there's a good team and it's properly resourced and it's well managed, then that's something that you can generally work with.
Is it becoming harder, Imtiaz, to manage a busy practice in circumstances where cases are becoming more document heavy, electronic data is more significant? You have to sometimes direct strategy, be across the forensics and know what the documents say. How do you meet that challenge?
Look, I think it comes back to what Liz was saying, that in a sense, as barristers, we're largely dependent on solicitors to help us with that. And you can't overstate the importance of solicitors in terms of giving us the support that we need to do our job. And whether that's people looking through a large body of documents to try and pick out at least a first cull of what they think is relevant, or whether that's just organising documents in a way that we can digest it. Whichever approach you take, it's very important.
Are you seeing a change in the cases that you're briefed in? Are they getting larger? Are they getting more complex? What's the mix looking like from my practice is a little bit more uniform in the sense that these class actions are large scale productions, 4 or 5 years. You can get into a certain cadence and rhythm. You maybe don't have that luxury.
I think we have more of a mix, or certainly I have a mix, and there's some things that come and go, and then there's other things, some regulated cases that are reasonably confined, but the class actions obviously are very large cases. The commercial class actions go for a long time and they are very complicated.
Yeah, look, I think there is a mix, and in part that's self-directed as well, because you want a little bit of a mix in terms of large cases and small cases, because if you construct your practice around only large cases, there's inevitably going to be big gaps between them, and to be honest, it just gets a little bit boring if you're doing one type of case over and over again.
Focusing on class actions for a minute, I'm thinking about an environment that's been changing fairly rapidly externally, like we've got a parliamentary committee looking at class actions, the ALRC, Victoria and nationally. Lots of recommendations for reform, change to the continuous disclosure law, change to funding regulations. It's a choppy environment. Through all of that, I'm not sensing a diminishing rate of frequency of shareholder claims, but maybe more diversity in the claims that are being filed. Or can you comment on that?
Yeah, look, I think, at least my experience is, there's kind of waves. So, a couple of years ago, there were a lot of shareholder class actions. Then for a little while, it switched back to product liability actions. At least my experience is there's a few more shareholder class actions now. And as I was saying earlier, you're starting to see things about competition law cases, which you saw right at the very beginning of the class action regime, but are now starting to pop their head up a little bit. And I think it partly comes back to the idea of, with a class action, what you're looking for is some sort of claim which involves an element of commonality. And I think that's the sort of key touchstone that the plaintiff firms are looking for, is trying to isolate areas in which there might be an area of commonality in the nature of the claim, in respect of which a claim can be brought.
Liz, this is a bigger question than the current forum allows us to really get into the detail of, but are class actions, do you think, achieving their purpose in the sense, do you observe from the matters that you're doing that they're actually achieving outcomes for group members? Are they providing new avenues for access to justice? Is it imbalanced in the sense that there's a little bit over focus on the shareholder space, maybe not as much on the social justice type claims? Or what's your sense of the environment? Is it changing?
My sense of the environment is that it probably isn't doing what it should be doing, and that is achieving justice for a lot of people. And that's because the cases that don't have much money in them are often cases that actually people really need their claims litigated, but they won't be picked up because the funders aren't interested, and not too many class action firms can afford to take more than one or so a year of those on and push them right through, especially against a well-resourced defendant. And in terms of the larger claims, they tend to get buried in years and years and years of sort of interlocutory stuff, lots of documents. Plaintiff doesn't know what its case is. And by the time you get to the end of it, there's a very big integer of whatever the settlement sum is, or for that matter, a judgment sum, which is going to be allocated to costs and interest. And so I don't know what the answer to that is because they're complex claims, but that's not what Murray Wilcox had in mind when he drafted the legislation in 1987 or whatever it was.
It does look like a very different practice to the one that I think Part 4A was designed to facilitate. Can, just before we pivot away from class actions, can I ask you one follow-up, which is not all of our audience won't necessarily have a full appreciation of what it means to take a class action or any complex piece of litigation to trial. You are both experts in that space and you've done it many, many times. My observation is, from having done it with you occasionally, that the amount of work involved is obviously enormous, but you need some things to align. You need witnesses who are prepared to cooperate. You need experts who are true specialists in their field. Just give the audience a flavour of the enormous effort involved in taking a case to that stage where you're actually advocating the position before a judge. Imtiaz, you look like you've got something.
Well, I can tell you an anecdote. Yes. I can tell you, my wife said to me, if I'm going to divorce you, I'll divorce you in November because you always have a large case in November. Right. And it's often the case with you.
Yes, I apologise to her as well.
But I mean, that's kind of it's a guide to the level of commitment that you need to run these type of cases, because they can take over your life for a period, and you really do have to give your all, because not only for the benefit of your client, but also out of respect for the people you've worked with, because these are cases which have built up over a period of years, and really once you hit trial, you're really hitting the pointy end. And in order to do justice to the case and the people you've worked with, you do need to give it your all.
One comment I have is that we're litigating these cases at a trial so far after the actual facts of the case that there's a level, I don't say this pejoratively, but there's a level of artificiality about what we're doing in that context.
There certainly is.
Yeah.
Because I'm in company executives and things happen. Sometimes they're very senior. They happened 10 years ago. They don't really usually remember, what happened. They can read documents and they can speculate about what might have been the reason why they did things. But it is artificial in that sense. And that's, I think, unfortunate, because it's, the actual truth-finding mechanism of access to justice disappears, and it really just becomes a question of who's better prepared, which I don't think, again, was what was intended.
Yep. And I did say I'd pivot from class actions, but one last one on that. Without inviting you to comment on the policy of this, but the state of the law is there is not perfect uniformity in the way class actions are run between the states and at the federal level. Differences in how lawyers are remunerated, some different approaches to things like class closure, maybe a different view on common fund orders. In practice, is that creating extra challenges for the clients that you represent in terms of sort of predictability about how this case is going to actually unfold and getting certainty around quantum and those sorts of things? Is that a problem?
Look, I think it is, in the sense that where you have procedural differences like that, you're really just encouraging forum shopping. And I think that can be a real difficulty, because it means that the outcome in the case can sometimes not be driven by the merits of the case, but sometimes by differences in personalities or jurisdiction in which the case is being litigated, which, at least from my perspective, that's not a good outcome at a policy level.
So a question to both of you, which is, again, a broader question than we have time to do justice for, but undoubtedly we've made some strides in the legal profession to advance proper representation and diversity within our ranks, but it's uncontroversial to say we're not as far as we should be. Even on gender, I think partners within law firms, far less than a third. So there's a long way to go, and I'm interested in each of your comments on what the profession can do to make sure we are representative of the communities that we work in. Liz, starting with you.
Yeah, we haven't gone anywhere near as far enough as we need to go. I mean, women leave the profession when they hit a certain level in droves because there's not a support for the fact that they've got children and they've got lots of other stuff happening, and it's very stressful, and it's not multidimensional. And it actually can be, and one of the benefits, I think, of COVID has been that a lot of people have worked out they can operate quite efficiently at home, but yet it means that they can do their work and they can still spend quality time. So there's less friction in the household. Their kids are sort of, enjoying their company. I think that's been a sort of unforeseen benefit, I think, of that experience. And in terms of diversity, yeah, it's full of white men at the law, and it is getting better. But it's a slow road, and it's full of people who went to private schools and selective schools, and I think it's very important that we reach out to more diverse backgrounds and encourage people and give them a leg up.
Is it as much a mindset that needs to change as opposed to actual tangible steps that the profession needs to take to make sure we're not blinkered in our approach to the talent that we absorb?
I think it's a combination of lots of different factors, but it's also the feeder that comes through, and the people that get into law school and the people who've got the opportunity to go to law school in the first place. I think it's a combination of things.
Imtiaz, a long way to go still, maybe some improvements, but even in the last 24 months around questions of creating a workplace that's fair and equitable and free from harassment, there's an enormous amount to do.
Yeah, look, I agree with that, and I agree with what Liz said as well. For me, one of the key elements is creating pathways for people to access a profession in circumstances where they may not appreciate those pathways exist for them. And I think it's really going out to people who traditionally you may not see in the legal profession and saying to them, this is a place that's open for you, and this is a part of a group that you can be part of.
In the way that the bar selects readers, and is that changing? Is there more of a focus now to ensure that we're reaching out to people that don't have the same level of access as others?
I'm not sure there's necessarily a focus on that. I think it's partly evolving over time. So I think people are more conscious that they need to be more inclusive and open doorways to people who, for whom doorways may not have been open previously. So I think that's good. One might ask whether there are more formal steps that can be taken, and I think that's something that needs to be explored.
Liz, on flexible work arrangements, is there? I know that there is a bit of a push within the court structures to return to in-person hearings, and I understand there are a whole lot of forensic reasons for testing witnesses and all that. But has COVID taught us anything about how we can sort of work more remotely and virtually generally that might be of assistance?
Look, I think it has. I mean, I've got a case management hearing before a judge who I won't name in the federal court, who actually said to us at the last case management hearing, it's not a hearing, I'd like you to turn up in person for the hearing, but it seems to be much more cost effective and less trouble if we just do everything online for, just 10-minute hearings. And that's made a huge difference in terms of flexibility. And I mean, I imagine you were the same. I had years and years of going to Melbourne on a Friday, and you'd go late on Thursday night and you wouldn't get home till 3 o'clock on Friday, and you've just written off all that time at vast expense. And for no real reason other than the formality that the bar and the profession had thought was just the only way to go for a long time. So I think I'm not sure about the movement back towards everyone must be at work. I think there has to be a balance. And I think, as I said before, there's got to be recognition that there's been some positive aspects of that. And it's felt, I think, men, and not just women, men and women who are parents of young kids have felt empowered because they haven't had to go into work and do that sort of stuff. They've been able to manage their work-life balance a bit better. And mostly successfully. Yeah. I guess there's probably been some bad performances, but I've fortunately not fallen into any of them, other than my own teenagers. But
I have a last question you'll be pleased to know, Liz, which is I know you both well, and you're my dear friends. But I'm also I deeply admire how you approach your practices and the way that you present yourself to the courts and the way you interact with our team. It's the representative of the best of our profession. A personal question, but I was interested. Many of our audience won't know how you have each progressed to where you are in your career now. Now I know it's a long story, so I don't need don't go year by year, but could you give each just a flavour of how you've progressed to this stage, the ups and the downs and what you've enjoyed? Liz, I'm happy to start by seniority with you.
So what, I was born here.
Yeah, that's right. Yeah, we can skip forward a little
dark
bit.
World, yeah.
Yeah.
Well, I got into law school and I enjoyed law school. I loved mooting, I loved debating. I did a lot of that. That's the stuff I watch in my 14-year-old now is just me. I was obsessive. I did all that sort of stuff. I was fortunate enough to be able to work for Justice Murray Wilcox on the federal court, who was a real role model for me. And he was not only a wonderful intellect, he was a very moral man and taught me very much that the right thing to do is a very important way to live your life. Then I went to a big firm for a year, but it just didn't click and I was desperate to get to the bar. So I went to the bar, I was young, I was 26.
Yeah. And is the one of the attractions being able to sort of, you're your own boss and control your own destiny and you're the face of the case and you're...
I think I was so young, I was completely naive about any of that. I mean, I didn't have a mortgage and, I whatever it was that I was being paid as a first-year solicitor at Allen's was, in hindsight, quite a small amount. I didn't have I might have had a cat, but that was probably about it. I think I had a car, but I'm not sure.
Right.
So I was a bit naive about that, but I loved the advocacy. And I thought where I was not quite working, so I was always going to go to the bar at some stage and I just went earlier than I otherwise thought I would have, and that's just ended up being a bonus, I think. And the flexible hours and so on has been a bonus.
Yep. And Imtiaz, your journey?
Yeah. So I went to law school and absolutely loved it and loved the intellectual engagement of it. Like Liz, I was really fortunate when I left law school. I worked for Kevin Lindgren as my first job out of law school, and it was pure luck I ended up working for him. But it was one of the really formative experiences because he was just a lovely man and an incredible intellect and incredibly hardworking. After that, I went to a law firm for 7 years, which was probably a little bit too long. But
I'll try not to take offence to that. I've been in a law firm for 22 years, but
yeah. But I did a master's in the middle there. But I stuck around the law firm because I thought I needed to get a bit of the green off me. 7 years might say it's a bit too long.
Mouldy, mate.
Yeah, exactly.
He was mouldy when he came to read with me.
But you've knocked the mould off him.
Mostly I had to shake it up occasionally.
Yeah. But ultimately I decided to come to the bar because it was something that I'd always wanted to do. And I figured, to be honest, I don't want to be on my deathbed wondering what if. And I figured if it'll work out or it won't work out, but at least I'll know one way or the other. And I've really loved it. I've loved the intellectual engagement. I've loved working with people like Liz and you.
I'm glad you got that in.
Of course. But it's just been a really good experience.
Did you each have goals as to the kind of practice, subject matter areas and specialisms? You're both obviously deeply involved in class actions dear to my heart. I know your practices are more diverse than that, but do you set a goal to do that or do you fall into it because you do a few and the market recognises that?
I think it's the latter. Yeah. When I was at uni, I loved public international law. And we both did Jessup, actually, I think 8 years apart or something. I loved that stuff. I thought it was fantastic. But going and living in Canberra and working for DFAT didn't really appeal. And I didn't want to go and work for AGS. Sorry, AGS. And that was, but administrative law I loved as well. And I just fell into this sort of stuff.
Yeah. You too, Imtiaz?
Yeah, it was much the same. So the sort of work that I'm doing now is a lot like the work I was doing when I was at the law firm. Yeah. And I mean, it was one of those things where I think I started doing this work when I was at the bar because people knew I'd done it at the law firm and had some background in it. Yeah. And I mean, to be honest, I enjoyed it. So it wasn't an unhappy thing that I fell into, but you kind of get into a groove and you get repeat work.
Well, if I may say so, you're both now leaders of that specialism as well as others. So look, can I say thank you for being so generous with your time to join this episode, and it's been really great to get the backstory. So thank you for your time.
Thanks.
You have been listening to a podcast brought to you by Herbert Smith Freehills. For more episodes, please go to our channel on iTunes, Spotify, or SoundCloud, and visit our website, herbertsmithfreehills.com, for more insights relevant to your business.